If you've been charged with a crime, the first question in your head is probably some version of this. Can these charges just go away? I get asked that question more than almost any other, and I understand why. When you're facing a criminal charge, the idea that it might just disappear, that the whole nightmare might be over right away, it's the thing you're holding on to. My name is Ernie Stone. I'm a criminal defense attorney in Massachusetts, and I've been defending people for 30 years. In this video, I'm going to give you an honest answer to that question. It's not the answer you might want to hear, but it's the one you actually need. I'm going to explain the specific ways that charges can and do get dropped in Massachusetts, because it happens more than people think. Stay with me to the end, and I'll tell you the 3 things that give you the best chance of getting there. Let's start with the most important thing to understand. The decision to drop charges belongs to the prosecutor, not the police, not the alleged victim or the person that made the complaint. Belongs to the prosecutor. A lot of people believe that if the person who made the complaint changes their mind or refuses to cooperate, the case automatically goes away. That's not how it works in Massachusetts. Sometimes the prosecutor can choose to move forward even without a cooperative witness. Whether they do that depends on the strength of the evidence and the nature of the case. So the real question isn't, does the other person want to drop it? The real question is, does the prosecutor have enough other evidence to prove the case without that person testifying? Because if the answer to that is no, then the case doesn't survive. Here are the most common reasons prosecutors drop charges or cases fall apart before trial. First, if the evidence is weak. If the physical evidence doesn't support the charge, or there are serious problems with how it was collected, a good defense attorney will find them. Prosecutors know when a case is going to be hard to win, and they don't always push forward on cases they think they can't prove. Second, when the witness doesn't cooperate. This is when the person who made the complaint actually has some degree of control. In those cases that depend heavily on one person's testimony, if that person isn't willing to testify, the prosecutor often can't prove their case, and they may have no choice but to dismiss. Third, when the charge was wrong from the start. Sometimes in the heat of an arrest, police charge the most serious thing they can, or they make the wrong charge. A good attorney looks at whether the facts actually support that charge, and sometimes they don't. Charges get reduced or dismissed when the legal elements simply aren't there, beyond outright dismissal. Massachusetts has several paths that resolve a case without a conviction on your record. These are worth knowing about. One is called a continuance without a finding, or QWOF, C-W-O-F. The judge doesn't enter a guilty finding. Instead, you're placed on probation for a period of time, and if you complete that probation successfully, the case is dismissed. It's not a guilty finding, but it does require an admission of wrongdoing, so it's a decision you make carefully with your lawyer. Another option is pretrial probation or diversion. This is particularly for first-time offenders in less serious cases. You complete certain requirements, and after a probation period, the case goes away before it ever gets to a finding. So there's no admission of wrongdoing at all, no guilty finding, just a dismissal. But it doesn't happen right away. None of these paths are automatic. They depend on the facts of the case, your record, and how well your attorney advocates for you. But they do exist, and in the right case, they work. I know what you're hoping for when you ask this question. You're hoping I'm going to tell you that yes, this is going away and your life goes back to normal. I wish I could promise you that. What I can tell you is this: charges do get dropped. Cases do get dismissed. People do walk out of the courthouse with their records clean without having to go to trial. But in many cases, that just isn't on the table. It's important that you remain realistic about what the real options are in your case. The path to the best possible outcome starts with understanding what you're actually dealing with and having someone in your corner who knows how to get there. This is not the end of your story. You'll make it through this storm.